Okay? Yeah. However, if you're going to try to defend anything in the public, then that's when the notary comes in handy. Because the notary is a public notary, and you can use those documents in the public. And that's the advantage.
So it's better to stay in the private, really?
Yeah, really. It's always stay in the private. However, if you need to go in the public, it's good to get your documents notarized before you file them in the public. Yeah.
Depends which happy way.
Yeah. It's a game. It's a game. Or you never the straw man. You always can choose to be the representative for it.
Yeah.
So as long as you draft it that way, so you're going to put your name, in the proper way, and then the authorized representative for the straw man. Yeah. And that's in the document, so they can't mistake that that's you. Yeah. You can even put under no circumstances is it to be presumed that I am this straw man, this person, this corporation called Mr. Blah blah blah. Yeah. Put it in the document. Exactly. You can't speak. He's a lunatic. He's a lunatic. All right. He's an incompetent. Can't even speak. He's down. He's right here. I'm representing him. I'm speaking on his behalf. All right. So where are we? So still number 3, page 3. Always respond to erroneous claims within 72 hours. When they say to use 28 days or 14 days or 21, they want you to go beyond the 72 hours, because after 72 hours it's assumed that you accept the terms of the contract. That's the game. So it's always 72 hours. So our stuff, we have it already. You have your acceptance of value on computers, you have your templates, letters ready, the way we set them up. So it just needs the filling in. So as soon as you receive one of these claims, put the details in within the same day. You can do it the same day. Yeah, it's coming in now. It's administrative work. Yeah, letter comes in, condition acceptance, it's council tax, you go to folders, council tax, or put the numbers in, print it out, give them the conditions. I need to see your paperwork within 7 days. If I don't see it, I'm going to assume that you've abandoned your claim, and you're not going to write him again. Done. Business. We're not your friends. It's business, guys. So it's not personal. You cannot get emotional. So you cannot get upset. It's a matter of administration. Yeah. So yeah, it's all business. The rest is the rest is pretty straightforward. You have enough time to read that. And then if we do number 5, page 5, converting legal disputes into factual disputes. Shouldn't you use the word disputes? I use the word disputes because I can't find another word for disputes. Disputes. I have to etymology. I'm going to find out what that word, the root word. Once you find the root word, I can know which word it is.
Putative word exists.
Oh, I went and found out this word here, man. I went and found out this one. I didn't know about this one. Wow. How about this one?
Privation.
Yeah.
What, sorry?
What does it mean?
Have you heard this word?
Yes, privation. Taking the way, isn't it? Private.
See,
It's
and then deprivation, yeah.
it's the same thing.
It means the same thing, yeah.
So if you put the D,
Pre.
it removes it.
Like French pre, to take. Pre, to take, yeah.
So it's privation that you want to say all the time.
Prendre,
People say,
yeah.
I'm deprived. If you're deprived, you're not deprived. You see, so this is no place privation.
Yeah.
I think what the, all the time we talk about deprivation. If you talk about deprivation, you have too much. Your abandoned is too much, man.
Yeah.
That's why they don't give you anything, because you live in a deprived area.
Yeah.
Because you have everything.
I just smashed my head off.
Yeah.
This is anyway, that's the twist, that's the term. Right? So if you're deprived, you're not deprived. Okay.
Yeah.
Right, so converting legal disputes into factual disputes. Right, so when you say things like, you have no authority, that's argumentative. And that's what they want you to do in court. But if you hear the way the lawyers speak, they never argue like that. They always say it in a different way. So so instead of saying you have no legal authority, you can say I believe your delegation of authority does not expressly authorize you to do that. You can say I don't believe that your delegation of authority allows you to issue these warrants. So It's about beliefs. I just believe. You see? Or it seems, it appears. There's never fact in legalese. There's never concrete. Everything appears or seems always. So you never make assertions like that. You always say, I believe. For instance, counsel tax against I believe that the doctrine of separation of powers does not allow you to issue judicial summons. Counsel tax, you see, not like that. So you're not creating an argument. I'm just expressing my belief. So that's how we twist it. So don't argue though. Come in another way. Yeah? So not always straight to get a and come in a hook, I don't know how, but come from the reverse. You see? Yeah. That's how you deal with it. Another one. Yeah, and then you carry on. So if you say, I'll just read this one. I believe your delegation of authority, order, or commission of the peace does not expressly authorize you to do what you did, and therefore you're operating ultra-virus, which means beyond your powers. That's a good wording. Instead of saying, you have no authority. Just say, hang on a second, I do believe that the power, the little power that you have, the limited power that you have, don't authorize you to do what you just did, Mr. Man. You see, you're this cheap suit, and you made up stories. I don't believe you, man. You don't have to shout at him, go and whisper in his ear. I don't believe you, man.
This is to the judge, right?
No, you don't get no select the judge.
To
Solicitors or
okay,
opponent party or clerk. The clerk can get
okay,
or usher or whoever is trying to mess with you. Or when they write you a letter as well. So the executive, which is the councillor, is going to write you, send you a summons. But under the doctrine of separation of powers, we know that, don't we? Separation of powers?
No.
Under that doctrine, democracy. It's a triangle still. In here you have legislative, executive, and judiciary. The executive is the cabinet minister, the police, and councillors, and all these people. They are here, the executive branch of government. You have the legislature, which is parliament, members of parliament. People go and sing and dance in the House of Parliament, and then they come up with some stories about some rules and regulations. This is here. Then you have the judiciary, who are the voodoo men, the men in black, the opium men, the priests. Right? Now the priests are the ones who are responsible for issuing summons, not the executive. You see. So how the hell can an executive officer issue you a summons? It's called the doctrine of separation of powers. Separation of powers. SIPA. What's the doctrine in the democracy, separation of powers? Which simply means that this branch of government cannot interfere with this branch of government, and this branch cannot interfere with this branch, and this branch cannot interfere with this. Each one is independent. So a member of parliament cannot come to your house to arrest you for any crime. That's the job of the police. You see. Same thing, the judge cannot make up law. He just has to interpret what's been given to him. It's the parliamentarians who come up with these stories. They're the ones who debate and which bills and act and create these rules. Judges don't do it. The executive don't do it. It's the legislature, the LEG, LEG. Alright? So the council is here, yet they're presuming to issue judicial summons for you to go to court. No. So, conditional acceptance, I condition accept to come to your court if you give me proof that you as an executive, under the doctrine of separation of powers, you have the right to issue judicial summons.
Which they don't.
I believe that you don't. I have council tax anyway. Council is so old, we don't even mess with that. But council tax, it's got its own specific talk. It's got its own paper. And we have paper from MOJ, Ministry of Justice. Let's say council will have an authority to issue summons. That's from Ministry of Justice. So that's all we use when council asks for tax. Just make a copy of that and send it in. Yeah. Okay. So that's what that is.
We're going to get a copy.
I don't think if I have it somewhere, but I wasn't doing council tax today, but I have a talk on council tax specifically. It's good, it's on paper. Yeah. So that's the separation of powers. Alright?
Yeah, Minister of Justice, yeah.
Okay. Another way to avoid argument is to... Right, another way to avoid the argument is to say, I shall accept any legal evidence you have that prove that I am under any obligation whatsoever as surety for your all caps. That's conditional acceptance. You're trying to tie in the all caps. In that way, it removes the argument. So you give them a positive performance contract. You're asking them to prove what they're claiming. You see, because they're claiming that you're a corporation. So you're accepting, fine, I'm a corporation if you can prove it. Okay? Or, the last one is always good, I like to use that. I'm in receipt of no proof of your legal capacity, legal authority, and legal scope of employment or office with whichever company you're using regarding the illegal instrument issued or signed by you. I'd say seemingly illegal, but everything appears to be. But those are the way you write to them. So it's not stating facts as such. You have no authority. You say I believe something contrary. That's all.
So when you write back to them, do you write back to them in capital? As a dead entity?
It depends. It depends. Because I write my contracts in English. I construct my own in English. So some parts are capitalized, but there's a way of capitalizing according to the manuals.
Okay.
Yeah.
So
the way they capitalize it is not English. This is legalese anyway.
So wouldn't it, so if I'm writing to them, I'm writing to a dead entity myself, isn't it? So would it be feasible to write it in capital or just sort of just write it as they write it?
Well, if you want to deal in that jurisdiction, then you write as they write it. For me, I'm no longer in the jurisdiction. I write my own contracts. It's up to them to read it and decide whether or not they want to come into business with me. I never ever go into that jurisdiction, ever. Because I'm living. And the corporation is dead. There's never ever that I'm going to go into that jurisdiction. Because I know what's up now. I know how to deal with it. So I never ever write in the lease anymore. And I never go into the jurisdiction at all. I don't even see their paperwork. It's called evil. Remember? The good and bad, evil and God? We don't see any evil, we don't hear it, we don't speak it. So we don't speak legalese, we don't hear it, and we don't see it. When you show me legalese, I am sorry, mister, I don't know what you're talking about. And I give it back to them. I have no idea what he's saying. I don't know these things. I went to school in Africa. This is not English. You give me anything you want. But if I don't know this, as long as you don't understand what's there, you cannot be... If I don't understand it, you cannot force me to understand it. And that's what they do to you in court. You go and try and speak to these people. They just ignore you, man. You can rant and rave, they don't see you at all. So you have not to see them also. When they write you in this dead man's, called the language of Rome, the language of the infants, the illiterates, this is illiterate talk. So we're not illiterates anymore. Nowadays we know how to read and write. So we write them in English. I might have samples, I'll show you, I might have samples in there of some English wording. In fact, one of those is English.
Not even
The sample of the...
English, isn't it?
Yeah, that's English.
So...
Conditional stuff, that's English.
And that's a good thing about the way that this document's constructed, because, I was saying before, you go to the living man. So he breaks it down so that there's no confusion, there is no... Are you talking about a mister here, or are you talking about the living man? The way it's broken down is... The living, this is the man known as, who does business as operating at this place, under company number this. So, straight away, you're going directly for the... living entity.
Yeah, you need to know what you're doing.
We'll look at that.
Because the corporations are just that, they're empty buildings. However, in these buildings, people show up in the morning and make various claims. So you need to find out which agent you're dealing with. You need to be dealing with a man or a woman, because you cannot deal with an empty building. So when you call, you need to speak to someone who's living. And that's the only thing you can deal with. You cannot deal with a dead corporation. They cannot write to you. Somebody has to actually take the piece of paper and write it. But now, because it's artificial intelligence, council tax has become machine now. So if you don't pay up, the machine just coughs it out every month. I don't want everything to be like that, so you cannot even negotiate with anyone. So in our documents, you say to them as well, you want your matters dealt with by a living man or a woman, and not processed by electronic means. But you have to put your own contracts, everything, all law is contract. If you don't say anything, we carry on the way we carry on. But you as an individual, you have to suit you and your circumstances. So in your contract you say how you're going to service, everything you want the way you want it. If they want to do business with you. If they don't like your terms, they can move on and do business with someone else. But these are my terms. Come into my jurisdiction, these are my terms. This is my house. If you want to come to my house, collect money, this is how I play. If you don't want to play this way, you go and play in somebody else's house. But that's what it is with jurisdiction. But this is legalese. You can still use it. The trouble is, under their rules, all contracts written in the language of Rome belong to Rome. So the judge ultimately has a final say. Regardless of what you write in them, you can decide to see it or not to see it. I mean, I've been to court, in the High Court, where I filed affidavit and the judge says to me, I can't see it. And it's right in front of him. So I had to read it out to him. He says, right, I cannot see. This is right in front of him. Why? Because I'm living in his legal fiction world. And when I went in, I didn't set the ground properly. I just went in assuming that he's going to be honorable and he's going to do a proper trial. But he says to me, I cannot see it in front of him. Yeah.
He said that.
Yeah. Yeah. But I didn't know then what he meant, but afterwards I came to know what he meant. I cannot see it. But it's coming from the living.
Yeah.
It's written by a man.
That's fantastic, that, isn't it?
Yeah.
Very
Initially I didn't know what the hell. I can see it. It's right there, man.
Yeah.
It's right there in front of you, and I'm here with you, and I can see you can see it. We have the same document. We are referring to the same document.
So what would you do differently now? What would you do differently?
To do with cases.
No.
If that happened now?
Oh, now the first thing I put the judge on oath before I said anything on the court, because I let him off the hook, because I thought he was going to be honorable. So I went into court, and I asked him about his oath. He said, yes, I have it, it's been a while, this, that, and the other, and just let it slide. You see, so I didn't put pressure on him.
He said he had the oath.
You want to see it?
Yeah, what I should have done, ideally, is to take a copy of the oath, and you have to put it in front of your case file, the bundle. That's the only way you won't get ripped off. Because the bond, that's the surety. Alright? His bond is the surety that he's going to be fair with you. You see, for that case. If it's not there, he can do whatever he wants to do.
So you have to get that before the court case, or you just say,
Before the court case.
proceedings while we get this
No,
off?
that's one of the conditional acceptances. I'm gonna come and be party to your proceedings if I can see, if I can get a certified copy of the judge who's listed to sit and hear this case. This is way before the hearing. So if you go to court, it's just, excuse me, I want a big copy of the judge's oath, please, of my file. And they're going to say they don't have it. Okay, it could be adjourned, please, until you can get the oath. Adjourn the case until you get the oath.
So you're already setting the proceedings before you get before you even enter into the
Exactly.
arena.
When you go to court, you know exactly what you're going to there for. I'm just going to see the judge's oath. If he doesn't have it, I'm not taking part. You see, but don't get caught up in arguments in court. You do it beforehand. That's the conditional acceptance. I'll come to your court. It's a real court of law. We have the acts. They've changed it. There used to be the Courts Act. Now it's called something Tribunal, something Act. That's a new one, 2007. And there's conditions there. The courtroom have to be provided by Lord Chancellor. That's one of the questions we used to do for council tax when they invited to court. Is this court, we conditionally accept to come to your venue if it's provided by the Lord Chancellor in accordance with the Courts Act. It used to be 2003 then. And we had the sections also. Oh, we don't have it. They've got zero, big fat zero. They've got nothing. These are fraudsters. They just perfected the fraud. And they keep people in fear. That's all. But they've got nothing. Alright? So, we'll do the example of the agreement. Same page, 5. So sometimes at the end, when you're doing your agreement, not the fall, but this part here, notice of agreement here, this one. So you're going to make notice of fault and counteroffer. When you're making your counteroffer, that's where you create the agreement. So for instance, give me your insurance within 7 days. If you don't give me your insurance, we agree that you're going to leave me alone. That's how you create your agreement. So you can say that if you don't respond to me, then it's going to prove that you have no legal authority to create, issue, or sign an administrative summons, or a notice of a lien, or whatever it reads. But that's how you write the agreement. And then conclusions. So you've done, conclusions are everything herein shall be admissible as relevant evidence of action without honor, based upon the uncontested issue of facts, which is a statement of facts, and the memorandum of law, which is that contained herein. That's how you finish it. This notice of fault. We're just going to say that if you don't respond within the requisite time, it simply means that you accept the plain statement of fact. I'm a living man. I'm not a franchisee. I'm not a person. I'm not a segregate person. And you also accept the memorandum of law, which is maxims of law, which means it's a fraud considered fraud, which means no man can create a rule of another man, those maxims. But they agree with those maxims. Once they're in agreement with those maxims, they have to let you go. The claim is finished. Yeah, that's how we concluded. And if the claim is finished, then you're going to rely on your letters as admissible evidence. So you've told them everything is plain. When you go to court, you just say to the judge, please refer to that paragraph, which said I was going to rely on this document as admissible evidence. Done. Please finish. Remember, he said that a court can only gain jurisdiction over a living man by effective service of legal process. Not frank mail, because we get frank mail, we open it, we respond to it, boom, subject matter jurisdiction gained without your knowledge. You see. And then finally, number 6 is some of the wording that I put on my contract to restrict what they can do with it. Number 1. The contents of this correspondence are copywritten, copyrighted, and may not be shared with third parties or entered into any kind of electronic information system or used for any kind of enforcement activity. Right? So no electronic system. I want to make the stock processed by a living man or woman. You can add that in there if you want to be clearer. Right? The DPA, that's the data protection. I will use the numbers myself. If I was going to use acts, I put it in brackets. But normally I just say, I normally use the data protection principles, so I won't use the numbers. Because as soon as you use one of the acts, it means you're back in that jurisdiction of this statutory legal fiction. So ours don't have any acts. People don't have acts. People deal with each other straight away. I don't have to speak to you according to speaking to each other's act of 1972. But in their world, that's how they operate. You come to speak to me, I just be silent. Talk to me, I just be silent. And I can take them aside, I'm not allowed to speak to you according to the 1972 Dance Speaking Act. It's stupid. Well, this is what we're dealing with. Yeah, this is what we're dealing with. These are lunatics. This guy's off the tree. But yeah, this is what we're dealing with. Now, the other one is DPA and other privacy laws require consent of the data subject in order for a data controller to maintain any records, and I deny my consent to electronic records. You need to remove your consent. Acts require consent. DPA is a deadly one. They don't like DPA, though. We've been kicking the ass with DPA for a long time. Data Protection Act. All corporations have to have a data protection department and control also. This, somebody works with data protection only, that's not each other. And they have to comply with DPA 1998, which is they have to get consent to maintain and control personal records of the subject. That is it. I don't like those words, but that's the wording of DPA. If you're going to use statutes, that's the wording. I don't use the word data subject. The data subject is like a taxpayer. It's like a driver. Data subject. Which is a subject. A subject is like a suspect. A suspect is like a culprit. Detainee. All those legal terms, they don't apply on man. You see. You want to be man all the time. Because according to their rules, God created man. That was the only creation, there's nothing else. And in that paperwork, they want to remove man from paper and make it person. That way man doesn't exist anymore. Person is artificial. It's corporation. That's the entire fight. They want to remove man from... So they're going to put man all the time. Man. No data subject. Man. Okay, and then you... because it's commas. all this is to do with administration. So you need to charge people for wasting your time. Because every time you receive a letter, you have to sit down, read it, stress about it, call a few people, try and resolve it. It's a waste of your time and money. So for that time, you need some money paying. Alright? So you can add whatever fee. You can say the fee for validating the copyright is £1,000. You can put a condition acceptance, and then in your agreement say, listen, if I don't receive details of who your insurer is, and you write to me, I'll be charging you $250 a letter for administration fees. Yeah. That's why they send you a letter, you bill them $250 each. Depending on how busy you are, you charge £1,000 for your time. I'm very busy, I don't even open those things. For me, if I'm going to bill someone, it's going to be around $500 per letter. So for me to open it and to sit down and type out all this crap in response to it, I'm going to charge you $500. Wasting my time. I'd rather be out climbing a tree, I don't know, or doing something else than dealing with this fake government. Sure.
Back on the DPA, I've had a tip-off that the 2018 DPA has reversed the presumption that now you've got to tell your bank that you do not consent to them sharing your data with third parties.
Yeah.
And I've got a template. If anyone wants, I can send people a template. Someone sent me a template.
Yeah, that's the next game, because what they're going to do is they're going to start taking your account straight away. So if you don't pay your parking tickets, they're going to take a picture of your car, for instance speeding, send you one letter. If you don't pay, they take it straight from your bank account. Yeah, that's what's next.
Is that what all this?
Court case, we said be straight.
Is that what this GDPR is somewhat related to?
Yeah.
The banks are going to do that.
Okay.
They created a rule.
Okay.
They created a new rule where banks are allowed to do that.
Right.
So unless you give notice to the bank that I deny consent for you to give my information or give out my money to third parties, they're going to carry on.
Yeah.
There's presumptions. They operate on presumptions. They just presume things.
Okay.
If you don't rebut, they just carry on.
Yeah.
Ruthless. They're ruthless. So the last one, we just finished this off and then we're going to take a break. So the letter and all attached documents can, shall and will be made part of the public record. It's private so far, but if they want to take it public, you're going to make it part of the public record. It will be used as admissible evidence in any commercial, administrative, judicial, or proceedings at law equity. Law is to do with this stuff, civil. Equity is to do with mortgages and things like that. Alright? So you can rely on that document. But you need to put those wording in those documents so when you produce it, it's not a surprise. You just refer the judge to the paragraph that said you're going to rely on it. But that is it. That's how you deal with commercial claims. It's conditional acceptance or nothing, or acceptance. So it's acceptance or conditional acceptance. Acceptance for value or conditional acceptance. And those are your responses. If you want to argue for fun, do it. But don't do it thinking that you're going to win through argument. Just argue because you want to learn. So write back and forth to them and find out what the position is. You can tell them that. Alright, is that okay? No questions before we take a break?
Like how I'm going to Tottenham's housing at the moment, and I had to pay them some money when I was in